that's 6 o'clock by that time. With the public service announcements at least. Ladies and gentlemen, if you could be taking your seats, because I don't want to hang about, because there's an important football match on later this evening. So, a couple of public safety announcements first. If the fire alarm goes off, as there isn't a scheduled test, we will all assume that it is an accurate alarm, because it will either be that or the wiring's overheated like the rest of us. And the Democratic Services Officer, Mrs. Snook, will find a way out of the building and hopefully will alert the rest of us to what it is. We will hopefully be having a scheduled fire alarm test at some point this year, because it's a long time since we've had one. Second public service announcement. Can I ask if anyone is intending to record or film this meeting? That's not to stop anyone doing it. That's just to find out that case and to let people know it's happening. No? So we're just left with the council's own webcasting of the proceedings this evening. Okay, without further ado, we'll move on to the actual business for the evening. Item 1, apologies for absence. I already have them from Councillor Perry and from Councillor Round. Anyone else? And Councillor Reeves. Thank you. One councillor did apologise for late arrival, but as he's actually here, I don't think there's any need to give that apology. Item 2, notification of substitute members. I see at least one substitute member.
Councillor Wendy Young from Sutton Valence and Langley. For Councillor Reeves. Thank you.
Right. Notification of visiting members. I'm informed that Councillor Bryce is on her way, so we will take note of that and hope that she arrives. Now, any other substitute members, visiting members? Councillor Powell, will you indicate it first? What are you here for? Councillor Mr. Hinden. Thank you very much. Councillor Springett. Thank you very much. Councillor Mrs. Sams. Thank you very much. Is there anyone I missed? No, good. Sorry, Councillor Powell, are you here as a ward member, or you're not a ward member, are you? You're here on behalf of the parish council. So you're not a visiting member this evening, in fact. So delete that. Thank you. Right. Items withdrawn from the agenda. I'm not aware of any items withdrawn from the agenda. So there are none, which is just as well, given how short it is. Item 5, date of adjourned meeting. Well, we shouldn't have an adjourned meeting, and if there is one, something's gone hideously wrong, so we'll forget about that. Item 6, any business the chairman regards as urgent, including the urgent update report as it relates to matters to be considered at this meeting. Is it agreed we take the urgent update report? I'm sorry, I couldn't hear a word. Is it agreed? Agreed. Thank you very much. Item 7, disclosures by members and officers. Are there any disclosures? Councillor Harwood.
Thank you, Chairman. In relation to items 17, 22 Goldstone Walk, I need to disclose that I'm a member of Boxley Parish Council, but that I have taken no part in any discussion of this application, and I therefore intend to speak and vote. Thank you.
Any other disclosures? Councillor Barfitt-Reid.
Yes, item number 15, I'm predetermined.
Thank you very much. So you will be taking no part in that discussion?
Yes, correct.
Anyone else? Councillor Spooner.
Thank you, Mr. Chairman. I need to disclose that I'm a member of Bearsted Parish Council, but I did not participate in any of their discussions relating to item 16, land to the south of Cross Keys, Bearsted, and I therefore intend to speak and vote on that item. Thank you.
Thank you, Councillor Spooner. Anyone else? No. Item 8, disclosures of lobbying. We will take those at the relevant time in the agenda. Item 9, to consider whether any item should be taken in private because of the possible disclosure of exempt information. Happily, unlike some other committees of this council, we don't have any. So I intend to take all of the items in public. Item 10, minutes of the meeting held on the 30th of May. Can I have everyone seen those? Yeah, the accuracy of the minutes is fine, but we do have a matter that relates to a report that was submitted at that meeting, which is on your urgent update papers, and I turn to Mr. Mackey to explain what we need to do.
Thank you, Chair. At the previous meeting, members considered and resolved to grant permission for land at Loader Close. In the body of the officer's report and in the officer's verbal presentation, it was explained that the application would comply with our affordable housing policy in terms of the number of units and the 10-year split. However, following the meeting, it was noticed that under the recommendation, under the heads of terms, the affordable housing split was set out in error. So there was an inconsistency between the body of the report that you presented and the text of the recommendation. So for clarity, we're simply asking members to confirm that the resolution that they agreed was for a scheme compliant with the local plan policy, not the typographical error in paragraph 8 of the report. I don't recall that there was any assumption that it was other than policy compliant in the discussion.
No, as Mr. Mackey explained, the officer actually, in the presentation, and members were quite clearly, when they were voting, and certainly I was, were as a result of that statement, clearly voting on the assumption that was the standard policy, 70-30, but we do need to formally note that. I therefore propose the adoption of the urgent update. Can I see a seconder? Thank you, Councillor Harwood. Are we indicating? No, not. Councillor Spooner was, though. Thank you. All those in favour? Thank you. Right, we return to the normal sequence of events. Presentation of petitions, if any. No petitions. Item 12, is there any progress on deferred items?
Thank you, Chairman. I'm expecting the application 18505541, land opposite St Anne's, to come to the next planning committee, the July planning committee. And obviously the next one down, 1950271. There's quite a lot of further additional information that members requested, so I haven't got a time frame for that, but we will try and be as thorough and as quick as we possibly can. Thank you, Chairman.
Thank you very much indeed. So we turn our attention to the planning applications for this evening. We will start with item 15 on page 37, which is Parkwood House, West Street, Harwich. Mr. Bailey.
Thank you, Chairman. This is an application installation of a sewage package treatment plant and associated drainage field, pipework and equipment. This application was deferred at the council meeting on the 29th of April 2019, and if you turn to your reports, page 39, members requested clarification on points 1 to 6. I don't propose to go into a great level of detail because I think what's set out in the officer's report is self-explanatory in terms of what she sets out in page 40 on points 1 to, on page 41 to 6. She answers all those points that are detailed, especially coming from the Environment Agency. I would also just draw your attention to the urgent update report, because there was a query raised at the previous meeting from Councillor Bryce as to whether the Environment Agency had considered the pond, which was within the grounds of Parkwood House, and their response is clearly set out on your urgent update. I would also add, and this, I'm just going to go to Google Earth in terms of the presentation. So this is the site here, and you'll notice this is the location of the pond, and that pond you'll see has been infilled in any case. That wasn't done recently, I can't say when it was done, but going back on the reprographic exercise of these photographs, you can see it wasn't done recently, but it's no longer there. So notwithstanding the Environment Agency's comments that did take it into account in any case, that wasn't considered to be a watercourse or connected to a watercourse. So in terms of turning to the application, I'll very quickly go through the photographs just to refresh members' memory again. This is the site. I think members will roughly know where it is. So this is the application site here, where the package treatment plant would go in this corner, and then you've got the beds effectively that it would discharge out to in this area. So that pond is infilled, as you can see from the plan. Slightly enlarged plan. This just shows where the previous septic tank or the existing septic tank is, and where it effectively has been capped off in this location here. So members did request that that is removed. You've got comments on your papers as to why that shouldn't be removed, that they're proposing to infill that tank and seal it off so it's no longer used for that purpose. Removing it, and that is a common practice, you know, septic tanks aren't generally removed, they're infilled because it creates environmental issues. If you do remove them, it creates more contamination. So that's the existing run. This is the proposed, so you've got the new tank proposed here, and then net discharge is to the beds in this area along here. You show the existing tree plan around it and how it impacts on that, and that just shows it in a bit more detail. So in terms of the report, as I said, the Environment Agency have granted a licence already for the package treatment plant. They provided you with quite a lot of comment as to why that is acceptable, but I must remind members that members are considering the planning permission for a sewage package treatment plant. They're not considering about the environmental licensing regime, which is outside the planning control. So members, what members are focusing on today is the package treatment plant acceptable in its own terms, and the Environment Agency deal with the licensing part, and you have got that information in front of you that they have already granted a permit on that basis, and hopefully they've answered the concerns that you've raised previously on that point. And I think on this point the applicant has gone quite a way beyond, and I would also actually consider that this could be an improvement on the existing situation, on the basis that you had a septic tank which was leaking, and effectively the applicant could decide to upgrade that existing system. Now, I don't know where that discharges further outside the application site, but this is a self-contained product that would discharge to those beds. So it's not discharging to a watercourse, and I do appreciate the concerns raised by the neighbour to the north and the potential contamination, so I accept that concern, but that is a concern that's dealt with by the Environment Agency under the licensing permit and not to be dealt with by this planning application. So on the basis of that, members, you'll see the recommendation and the conditions attached to that report are set out on page 42 and 43, and the application is recommended for approval. Thank you.
Thank you, Mr. Bailey. Let's hope your voice holds up.
Yes.
I will now ask the legal office to explain how the public participation part of this evening works. Mr. Keane.
Good evening, ladies and gentlemen. This is a short announcement for members of the public, and particular those who are speaking on an item this evening. As you've just heard, the item is announced by the chairman, and then the planning officer introduces the item. The chairman will then call the speakers. When you hear your name called, please could you come forward to the table in front of you and take a seat. To speak, press the middle button. You do not need to hold it down. The button will turn green, and the ring around the mouthpiece on the microphone will turn red. You will have 3 minutes to speak, and you'll see your time counting down on the screen in the corner here. At the end of the 3 minutes, the chairman will indicate when your time is up. Once you've finished speaking, Please press the middle button again. It will turn white and return to your seat. You may hear some of the speakers referred to as visiting members. They are members of the council, but they don't sit on this committee. They will also have 3 minutes to speak, but they have no right to vote on any of these applications. Thank you.
Thank you very much indeed, Mr. Keane. The first speaker on this application is Mr. Bowden, an objector. If you'd like to come forward, sir. Entirely. It is entirely my fault. It's Mrs. Davis. I'm sorry. I skipped a line. It is my fault entirely. Mrs. Davis, please. Sorry. We do have these technical problems occasionally.
Okay, you're on.
Oh, thank you.
Poor Councillor Harper was silenced yesterday.
Okay. So is that okay now? Okay. Is that right? Yes? Okay, right. Okay. Thank you for that. A number of issues raised at the last planning committee appear to have been addressed. However, 3 important issues remain. These are unresolved wastewater misconnections, the safe disposal of chlorinated swimming pool water, and generator provision for maintaining power supply to the sewage treatment plant. We raise the issue that historic misconnections of wastewater at Parkwood House are causing serious issues for us as the directly adjoining property, and they contravene several sections of local planning policy DM1. Overall responsibility for misconnections lies with the property owner. A recent High Court ruling affecting misconnections at a property in Enfield is highly relevant here. This case is Mustafa versus Enfield, LBC 2018. The court found that Section 59 of the Building Act 1984 applied, where satisfactory provision has not been and ought to be made for drainage of a building. We repeat our request for the planning authority to investigate and apply conditions to correct this important misconnections issue. If left unresolved, we estimate possibly up to 75% of the daily wastewater discharges would pass directly into the environment, continuing to contaminate the surrounding area and chalk stream into the future, and causing serious safety and land slippage issues on our ground below. Full details of this key case can be supplied by our solicitor upon request. Local Plan Policy DM1, sections 2, 3, 5, 8 and 11 also apply to this issue, particularly sections 8 and 11. Similarly, safe disposal of the chlorinated swimming pool contents was not addressed by the Environment Agency at all. We are advised that the precautionary principle is still in force at this time, and the owners should demonstrate a totally separate, safe system for disposal of the swimming pool water, i.e. removal by tanker or other means. A condition should be included on the consent that any proposal for the treatment plant should not include accepting swimming pool water. Section 59 of the Building Act 1984 also applies here. Continual provision of power to the treatment plant is of paramount importance, and a generator should be installed to provide power in the event of a prolonged power failure, as has occurred in the past. As the unit selected will only operate for 6 hours without power, the system is at risk, as UK power networks cannot always guarantee to restore power within 12 hours, depending on the severity of the fault. This leaves a significant shortfall in time, and just one prolonged incident will cause contamination. It will also cause anxiety and distress to the vulnerable residents at this assisted living care facility who have learning disabilities, physical disabilities, and associated complex needs. This makes it even more important to install a generator on site to ensure their continued care and safety. Thank you.
Thank you very much. Councillor Powell, whichever hat you're wearing.
The Parish Council still have concerns regarding this application and wish further conditions to be attached to any planning permission granted by this committee. In addition to the archaeological watching brief at section 4 of the planning report, the installation of drainage field is to be overseen and approved in writing by the local planning authority. This is to avoid confusion and to ensure it is located correctly, as shown in the amended site plan dated 14th of June 2019. In addition, the location of the second planned replacement drainage field to be agreed and approved in writing by the planning authority so that space is available for this installation in the future. This is to be sited alongside the first field and further into the site, away from the tree root systems that would damage the installation, as noted at the last committee meeting. To prevent environmental harm, an additional condition at section 5 is needed to exclude chlorinated swimming pool water from being fed into the sewage treatment plant for disposal. This would damage the plant itself and overwhelm the drainage field. An alternative means of disposal is required, details of which to be submitted in writing for approval by the planning authority prior to first use. The vital importance of the provision of a generator backup system has been raised to protect the sensitive chalk stream and the River Len. In response, the applicant has indicated that the treatment plant will only work for 6 hours without power, but is not planning to install a generator on the site at all. The Harwich area has experienced prolonged power cuts in recent years. UK power networks attempt to repair the faults within 12 hours, if possible, but much longer power breaks have occurred in the local area. In the event of a serious power cut, the treatment plant would fail after 6 hours and cause unacceptable environmental damage. Prolonged failure of equipment and lighting in an assisted living care facility as Parkwood House would cause the residents extreme distress and serious safety concerns. The residents require 24-hour care and have complex needs associated with both learning and physical disabilities. Therefore, the installation of a generator at this location is essential for the safe operation of this site, both in terms of environmental protection and for the safety of the residents. Mrs Davis just repeated the concerns of the trout farm in relation to the misconnections of wastewaters at Parkwood House, draining into their adjacent property via the surface water system underground. As this is relevant to the installation of the proposed treatment plant and significant amounts of wastewater would bypass the system altogether to contaminate the surrounding environment, this issue requires urgent correction from the owners of Parkwood House prior to planning permission being granted. Thank you.
Thank you, Councillor Powell. Councillor Mrs Sams, please.
Good evening, councillors. When we met last to discuss this application, I said it was a very concerning application. I still stand by this. I'm still very worried about the large amounts of wastewater containing many contaminants that are escaping from the building into the land at the trout farm and into the natural water courses. This only happens when the property is occupied. This may well be a misconnection, and I think this is a massive problem. This, I do not believe, will go into the water treatment plant, so it will contaminate. We don't know where this water comes from within the building. CareTech do not know. What we do know is that it's not runoff rain from the building because it only happens when the building is occupied. It could contain anything, wastewater containing chemicals from washing machines, kitchen, bathroom sinks. It could just as easily be sewage. The other speakers have expanded on the ramifications of the situation, and it's really important that this is rectified. The Borough Council could be fitting the bill for legal action due to lack of due diligence, as has been explained by Mrs Davis regarding the High Court case that's just gone through. It's a responsibility that the Council must share. As I said last time, the whole building and system needs to be looked at before any plant is installed. The Victorian septic tank was found to be leaking. The system is very old and potentially damaged, and potentially there could be misconnections all through. The site is in an area of archaeological importance and a groundwater source protection zone. The site is located in a mineral safeguarding area. It's also adjacent to ancient woodland at the trout farm. I believe that it flies in the face of policy DM1. We cannot enhance the surrounding area if we're contaminating it. Surely we must make a stand against chlorinated swimming pool water getting into the freshwater courses. The power supply that's been talked about to the water treatment plant is vital, along with the residents' safety. Both are vital, and a caring company should be catering for a lack of power supply through a generator. These points that have been raised, namely possible misconnections, the swimming pool and the provision of a generator, all potentially lead to contamination of the watercourse and impact on the surrounding wildlife. I believe that you need satisfaction that these are all addressed by conditions today placed to ensure full protection. Thank you, councillors.
Right. Can I have declarations of lobbying, please? When I remind anyone watching that it is always a good idea to lobby substitute members of this committee and not leave them out, as appears to be the case. Right. May I also direct members' attention to the fact there is an urgent update on the papers, so please do have a look at it. Right, Councillor Harwood.
Thank you, Chairman, and thank you for officers talking to the various stakeholders about the key issues raised at the last meeting. There was a lot of discussion around the potential for chlorine getting into the system, and I do wonder whether there's another way around that to ensure tankerage or whatever that we don't see a release into the environment of chlorine, which can be very persistent. I will talk about the application more in a minute, but I am a little bit concerned now in that from the aerial photograph you've just shown, the most up-to-date photograph, it shows the very large pond at Parkwood House having been filled in. Unless that was filled in by hand, which I doubt because it was huge, that's an engineering work, and you would presume it would need planning permission. So I suggest there is an enforcement issue here, and associated with that, every water body in this area contains European protected species. There are great crested newts in literally every water body in this area. That's well documented. So not only has there potentially been a breach of development control, there has potentially been a breach of European protected species legislation, which is very serious. So I think regardless of what we determine on this application, I think we're going to need to have a bit of a chat about that at some point in this meeting to ensure that an investigation is carried out. Right, thank you. In terms of the issues which led to the deferral, I think they've all been satisfactorily resolved. I do question some of them because I know some of the things are a matter of record and which are being questioned. However, the one area where I am concerned is in relation to energy supply for the station itself, because we do know that Harwich is at the edge of the network. It is also very vulnerable to severe weather events, which in the past have led to very, very severe prolonged outages, the last one being the winter of 2013-14. And there Harwich lost all power for a very, very long period of time. And I'm concerned that a pollution incident here is not just a pollution incident in Harwich, it's a pollution incident in Leeds and Leeds Castle, it's a pollution incident in Moat Park Lake, it's a pollution incident in the River Len Local Nature Reserve, and it's a pollution incident in the River Medway. And I do think there is a profound issue there, and we are being told that in terms of adaptation to climate change, resilience of power supply is a key consideration. And you know, I did wonder whether some sort of a renewable energy solution, that if we did have the power was linked to solar panels or something like that, we could at least give a greater surety of supply in terms of, or even with you know, battery packs or generator. But I am very concerned about the time window where it talks about just a few hours, and that is, I do not believe, sustainable. So I would like the officers to come back on that point, and coming back to the original point about the potential engineering works that's taken place with the pond or lake, as I'd probably describe it better. I wonder whether, because we are being instructed that a net gain for biodiversity should be sought from planning applications, that potentially, if we do negotiate an outcome on this, that the applicants should re-excavate a watercourse somewhere to at least attenuate some surface water and to provide that net gain for biodiversity, because they've clearly initiated a net loss of biodiversity. Thank you.
Thank you, Councillor Harwood. I certainly don't recall a planning application being submitted on this site. So, you know, they really, regardless of whether it's through this application or another route, really need to reinstate that. Otherwise, I think we should be taking our own action or referring them to our legal friends, because that is quite clearly a breach of both national and European legislation. However, this application, as I say, it would be useful if we could avoid any action like that and actually have that improvement put back in this application. My concern, like Councillor Harwood's, is twofold. I don't think, in terms of the general pollution issues, that, well, give things in proportion. To be honest, you're going to get a higher degree of risk of pollution from runoff from farmers' fields in this area than you are from the facility itself, unless, of course, the power is interrupted or it has a large amount of chlorinated water going through it, which are the two main issues that remain, I think, to be resolved, although the parish council did make a number of points of detail about further plans and information required, which on the surface of it do sound fairly reasonable, so I'd be interested in your views on that. But the two main issues are the chlorinated water, which is another issue entirely than wastewater of the normal type, and the really short period of 6 hours, because I know in this area fairly well as I do that could I mean, it could be quite a long period of time. Suppose if this generator failed during the winter months, and Councillor Powell will have seen, and Councillor Sams will have seen, that I once attempted to walk back via Harwich from Lenham, and it took me a very long time to get through the accumulated snow and ice, and no traffic was moving on the road. So, you know, if this happened at the wrong time of year, it could be more like 6 days than 6 hours that it wasn't working. So some form of backup or extension of period to a more realistic level would be welcome. So, and actually I think probably quite essential, because it wouldn't take much to cause a major incident. As Councillor Harwood has indicated, the knock-on effect from this location in terms of where it could end up is quite significant. So a number of questions, really.
Okay, I get 4 questions coming from there. First of all, we'll deal with them in reverse. The chlorinated water. It is standard practice to put conditions on discharge of swimming pool in terms of chlorine and the impacts that can have. And I think it would still meet the test if you put a condition to say no discharge into the new package treatment plant until such times as details of how that swimming pool is going to be discharged. I don't know how it's being discharged now. As I said, this is Victorian property. You've probably got a combined system where the surface water discharges into the foul, so I suspect how it works currently, and that's probably how you're getting the issues of flows. That's historically what happened with drainage systems. Now there's a requirement under the Act to have separate surface water and foul systems for new properties, but I don't know what happens on the existing one. So I'm kind of answering 2 questions. In terms of a net gain here, you've probably got an archaic system operating in there. The benefit in terms of biodiversity on this scheme means that you are discharging effluent to a controlled system and a modern up-to-date system which doesn't effectively can find its way into a watercourse, because not only are you moving that system down into this area away from the septic tank here, which has an outlet somewhere in this location undetermined. So I would say that is actually a net improvement in biodiversity. But I think it's perfectly reasonable for you to condition, should you see so fit, to prevent discharge of swimming pool effluent to this new system until such time as they set out either that the system can accommodate it or they can set out details of where it discharges to an existing system. Now, I just say on the current basis, if it says that it's discharging to the existing surface water system, then you may not be able to exercise control on it, because remember, you're only talking about an application in this line. So I think it's reasonable with suitable wording, and I could construct that.
Well, at least we'll see what we can do on the other point.
Moving to the next point, I have addressed the issues in net biodiversity issues. Now, I would just be clear that if there is an enforcement matter that is separate from the decision you're considering, that should be separated and investigated in different matters. Now, going back on the aerial photographs, it does appear that that's been infilled for quite some time. From the aerials I can see going back to 2015, that's when the pond seems to appear. But again, as I said, if your engineering works, I'm just going back here on the screens in front of you, that's photographed on 4th, 2015, so it looks like that's still infilled there. And then when you go back in time further, it takes you back, so it looks like there's some sort of elements of a dry pond there, but it's inconclusive, and that's 2013. So I would just say disassociate yourselves with the enforcement side. If this committee say they want the enforcement team to investigate it, I will log a complaint on that basis and see if there's a case to follow, but please don't make that as part of your decision, because you shouldn't be considering enforcement with your planning application. In terms of the issues of energy supplies, I think it all comes down to the tests in terms of the reasonableness. Obviously, in your papers in front of you, building control manager's been consulted, and building regs deal with a separate application under the building regs, and they require 6 hours backup. The issue you've also got that sets out in your papers in front of you, that the permit, if there is environmental pollution controlling resulting from that discharge, that becomes an Environment Agency matter under the environmental permitting scheme, and it becomes their responsibility to deal with the environmental consequences that come from that, or any breach of the licence that's been granted. That becomes outside of the planning matter. So that you have to bear that in mind when you're making that decision. And then you also come on to the point that you have generators as backup systems. They are extremely expensive to have separate generator backup systems on this issue. Now, I'm not saying it's unreasonable, but you have to get past the test is that building regime only require a 6-hour system. You've got information here that says if the energy supply went down, no solids would be discharged. They would remain in the tank So you've also got that issue that there will be nothing being discharged out of that issue. So you've got to bear that in mind. And then is it reasonable on the probability that there may be a power cut more than 6 hours that you're going to require an applicant to spend God knows how many thousands of pounds on these generating systems as a backup measure that may never be required. So I understand the member concern, so I'm not trying to knock that out, but in my view, I don't think it passes the tests in terms of putting a condition requiring a backup generator to be supplied in this location. And I don't think it would pass that because the applicant would be able to appeal that. And, you know, you have got other measures and safety controls, not only the permitting scheme from the EA that would deal with the issue of any contamination or any matter that came around from that. So I don't think it's reasonable to impose that condition. And I do have to stress again, I think that this is actually a benefit. Some of you may not believe it to be a benefit, but you've got a system that discharges, I presume, on a combined system to a point that I've previously said, to a point I don't know where it discharges and what it does at this point. So no one knows what the system is. What you're looking at is a foul sewage system. That's all you're looking at, which seeks to infill the existing septic tank, cut off these areas of discharge here, divert the system away from a point of what some may argue as a point of close proximity to the existing trout farm. So I think in every sense it's an improvement, and these will have to be controlled by building regs. So when they're installed, they're controlled by industry standards. So I think what you've got is a significant overall betterment than the existing situation that at least is in your control and you can put conditions on. So I think overall, by putting all those factors together, you're on a scheme that this is quite a significant improvement over and above what you've got.
Just before we leave this sort of question and answer bit, at the very beginning of Councillor Powell's presentation, he referred to some further pieces of information about the parish council fall could be conditioned. Do you recall, in terms of the actual layout?
In terms of, I presume you're returning to the impact on the trees.
Yes,
well,
particularly.
yeah, I mean, if I turn you to the original report, page 44 onwards, where paragraph 5.05, page 46, where our tree officers have considered the location and the impact on the trees, and it says that the arboricultural report and tree protection plan is acceptable, and it should be added a condition to ensure that any trees damaged or lost within 5 years of the relevant should be replaced with the appropriate species. So that has been through our arboricultural team, and they raised no objection to it. And obviously this plan does clearly show the tree and the canopy spread and the impact of what is relatively a low impact ditch, where effectively you've got the pipe runs running underground and holes opening to effectively allow that water to seep out. So I don't think that there's any impact on those trees arising from this scheme, and that has been assessed by our in-house experts.
Anyone else wishing to? Councillor Wilby.
Just a quick question about the pump. We've got one of these actually in my ward at Hale Mill, which does empty directly into the stream rather than go to the beds itself. It has a holding bed and then goes out. Sorry, it has a holding bed and then comes out. My understanding is that the pump doesn't actually operate continuously, does it? It stops and starts and when it gets to a certain level as such. Is that correct?
I'm not going to profess I know the inward-outward working of these systems. I suspect a pump wouldn't be running continuously. It would come on as and when with a shut on and off and as and when it's required, because otherwise you'd be constantly pumping stuff, and at night time when people are asleep you wouldn't need it. So there must be a regulator that effectively switches it on when there's flow coming in the system, but I do not profess to know how the system works in and out.
Yeah, so my point with that is the actual 6 hours of backup is actually 6 operating hours of backup, so it could actually be a longer time. Yeah, so in theory.
Yes, that is generally true. Councillor Mumford, who probably knows quite a bit about pumps. And
I don't want to talk about pumps. I've listened. I tend to agree with the officer regarding the benefit. The officer's told us that we can put a condition in, or he feels it would be acceptable to put a condition in regarding chlorinated water, which I'd like to see. Misconnection that has been discussed, I don't think there's anything in this planning application that we can address that with. And where I do disagree with the officer is I think it's reasonable, based on probability and impact, that we ask for some backup source on the power supply. I don't know how we word those conditions, but I'd be willing to propose we grant planning permission with those two conditions in. That's where I am with the debate.
right, anyone else? Councillor Harwood.
Thank you, Chairman. There was some discussion around the point that's been raised by the Parish Council on impact on trees. Coming at this from a slightly different perspective, something called phytobioremediation, where you use willow trees, which are very good at actually getting particularly some of the nastier components of the sewage out, is utilised quite widely. And there is no landscaping condition attached to this. And I do wonder whether, because of the concerns in local parish council and because of the topography, whether actually there may be a certain element of insurance provided if we do include a landscaping scheme to both soften the visual impact along that southern boundary, but also if we choose carefully the tree species involved, they will not only prevent waterlogging of the ground, which is when there's a problem and you could see a loss of potentially contaminated water from site, but they would actually suck up some of the more persistent toxins which are likely to end up in the substrate. So I do wonder whether we can make an argument that a kind of willow car type landscaping scheme should be attached.
I would have thought that was a sensible course of action. Right, I don't see anyone else wanting to add anything or ask any questions, so we need to sort of whittle down what can and cannot be done. In terms of, I think the officers have accepted we can put a condition on in relation to the future outlook on the chlorination. Don't think there's a problem with that landscaping, is there? Can I just check on the landscaping where we'd be with that? I don't think that'd be a problem because that would actually be helpful in both senses.
I think in terms of, as long as we didn't put a reason that it's visual, because clearly from outside the site you can't see this and it's very, very low impact. If you put the reason on the fact that willow trees have a absorption capacity, obviously I don't know what the impact of having those trees in such close proximity to the drainage system and what the impact of that is. So it's certainly something that I think could be reasonable. I don't know if there's evidence to say that they actually do that.
Oh yes, there's quite a lot of evidence.
Because I don't know, I'm bow to your greater experience, Councillor Harwood, on that basis, but I say if members feel that it meets the tests and there are benefits arising from that, then I think it could be imposed, at least a scheme
as long as we're specific about it and the reasons why we're doing it.
I'm fairly certain that, from my own reading, that Councillor Harwood is correct on this point, and that there is a considerable benefit in terms of the absorbent detoxification qualities, for want of a better term, as has been discussed quite a lot in various journals. Unfortunately, I don't think we can do very much about the generator issue, because unfortunately it seems to be free falling in legislation other than planning legislation. So we could put it on, but I suspect it'd be struck straight off if the applicant didn't like it by and would prove totally unenforceable. So that's unfortunate. Is there anything else that members wish to add or at this point? Otherwise, Councillor Mumford.
Yeah. I'd like to propose, so you've got a proposal in front of you, that we approve this application with the inclusion of the excluding swimming pool chlorinated water from this new system, the landscape scheme that Councillor Harwood has suggested goes in as a condition, and also that a backup power source in the form of a generator or some renewable system is put in place.
I certainly see that we can do two of the three. I'm not sure whether we've certainly, let's see whether that's seconded before we go on any further.
Because that's a proposal.
Councillor Spooner, do you wish to speak to it now or retain your right? I think this isn't going to be a much longer debate, so
I'm quite happy to second Councillor Mumford's proposal. I do have concerns, though, about the condition requiring the backup generators. I just don't see that passing the test of circulars in 185 or whatever it used to be, the 6 tests. The other 2, I can well see them doing that because we are controlling chlorinated water, and secondly, on the basis of Councillor Harwood's expert advice, we can soak up any potential pollutants that may arise. Overall, I regard this as being an overall betterment, and the risks of any flooding or pollution must be reduced by carrying out this development rather than leaving the existing sewage treatment works or the septic tank to remain there. Therefore, I'm quite happy to support your proposal. Thank you.
Legally, we could strongly suggest that they do this by way of an informative. I'm not sure a condition, as you say, will pass a test. So I know it's a bit unusual, but I think I'd probably, rather than take an amendment, I'm going to sort of take a separate vote on that third condition as to whether that remains in the motion or not. Sorry?
Just clarify, Councillor Spooner, were you seconded that but not the third bit?
Councillor Spooner did second it, but I'm going to have a separate vote. I'm going to hold a separate vote on that particular condition, whether it stays in or comes out, because that seems to be the simplest thing to do.
It could perhaps be put in as an informative, perhaps?
It could be an informative. We could strongly advise, but I'd have to ask Councillor Mumford whether he's prepared to accept that drafting, well, rather more than a drafting change.
I prefer you put it to the test and you vote on the proposal as 2 conditions and then the third condition.
Okay. Those in favour of that condition remaining in the proposed recommendation as a condition. Those against? Abstentions? Right, well, that's defeated, but I will now have a vote on whether it should be included as an informative. Those in favour? That's everyone. Okay, so now I will move the substantive, which is to approve the recommendation on the papers with the urgent update plus the 2 additional conditions and the informative. Those in favour? Right, that's everyone. So no further votes needed. If you care to rejoin us, Councillor. And there will, due to the fact that I, like James, am extremely hoarse, I'm going to need to go and get some water. So if anyone needs a short comfort break now would be a...
Sorry, Chairman, just before you leave to get your water.
Sorry, the enforcement issue.
Yeah,
sorry, yes.
there's the enforcement issue, but also the issue around phytoremediation. Within the Kent tree strategy, which is still draft, but I think it does carry some weight as a planning document. It certainly was used recently by Thanet District Council. That has a significant section, and so I can send perhaps the case officer a copy of that section of the strategy, which would potentially be helpful in explaining the background to why this
That would be very
sought.
useful. I was going to leave the enforcement matter, but it's been raised, and I imagine the committee would like, I mean, we can't exactly instruct in case of enforcement, but we would like officers to look into that particular issue and see if there's any issue relating to the pond.
You can put a motion forward asking us to investigate.
Yes, that's what I'm just about to do. So I would like to formally propose, and to have a seconder, Councillor Wilby, that we ask enforcement to investigate the question of whether the pond has been filled in without consent as an engineering operation. Agreed? Anyone against? Abstentions? No. In that case, there will be a 2 or 3 minute break. Right, ladies, gentlemen and councillors, if we could be taking our seats and proceeding. I'm sorry I had to adjourn briefly there. It is so hot in here that I was getting quite dehydrated, so my apologies. Item 16, page 65, land to the south of Cross Keys, Bearsted.
Thank you, Chair. This is a Section 73 application to amend the layout of an already approved housing scheme. In 2016, planning permission was granted for 50 dwellings. Development has commenced, but only in respect of the demolition of some of the previous structures on the site. Otherwise, the site remains at this stage undeveloped. Development hasn't commenced in terms of the construction works. This is the view of the site from Roundwell. This is a view from inside the site, and members may want to note that you can see in the rear of this view properties in Sutton Street, and I think one of the key considerations in this application is whether any of the variations to the layout will affect those properties in particular which border the site boundary. This is the layout as approved. It says proposed site plan, but it was the proposed site plan that was approved. It isn't clear from that drawing, but if I go to the next slide, you can see highlighted in red that a feature of the scheme were cul-de-sacs. So there was no sort of gyratory within the site. Kent Highways and our refuse department have spent some time examining the principal risks associated with accidents on refuse lorries, and the principal risk is associated with lorries reversing. So they now recommend that we reduce, where possible, cul-de-sacs within developments. Therefore, the applicant has responded to that advice with a proposal, hopefully if you can see where the major change is here, that there is a gyratory system that allows the refuse vehicle to go in and out in forward gear. That requires some amendments to the approved layout, and the properties highlighted in red are those buildings which have changed as a result of the proposed new road. If we go through these in detail, firstly, the properties within the inside of the loop road, they have no effect on street scene, no effect on third parties, so I don't think we need to go through those in detail. But along this boundary of the site here, these are the rear of properties in Sutton Street. So I'm going to briefly just go through those parts of the scheme where there has been a material change. The first is this property, plot 16. I'm not sure how clear this drawing is, but this is the approved layout, and you can see the property sitting at the end of the cul-de-sac on a slight angle. The proposed layout shows that the property has moved towards the boundary with the neighbouring properties, because obviously the estate road that it fronts has pushed it south a little bit. However, if you look below the proposed alteration, I've superimposed the Google image of the neighbouring property. I'm not promising that's exactly to scale, but it does demonstrate the relationship between the two. You can see I don't know whether it's a stable or a garage block, but there is a non-residential element there with the main house almost on a sort of, it's not north to south, but a perpendicular axis to the site boundary. The proximity between the elevations is 32 metres, so that's well above our guidelines for facing elevations. And also you can see that the original property was a square footprint. The revised property has stepped the elevation closest to the site to reduce the impact of massing. Officers are content that there's no impact on amenity of neighbours as a result of that change. Again, this is just a slight zoom in to show the setback of the new proposed property. You can see it's labelled barn here. I believe it has sort of a room above, but it's not a habitable dwelling. The nearest windows in this property are in this part of the building, some distance away. So on that basis, we're content that the changes don't affect the neighbour. There are changes to the detailed design of the buildings, but in principle their character, form and materials are as previously approved, so we have no issue with the tweaked design of the building. The next plot, moving further along, is plot number 25. Again, trying to show the relationship between them. Again, this is a slightly more confusing drawing, but you can see the approved position here on the left, the proposed dwelling here on the right. The principal change is that the dwelling is straightened up in terms of its alignment with the garage. So in the main, it is no closer to the neighbour than it was before. You can see here the superimposed map of the nearest property in Sutton Street. Again, there's a significant spacing between the property, well above the 21-metre guideline. So on that basis, we also feel that this particular minor change doesn't affect the amenity of the neighbours or the character of the development. Moving along, plot number 27. Again, you can see that really it's a minor turning of the building in terms of its orientation. It's more perpendicular to the internal access road. Its relationship to the boundary. You can see the relationship with the neighbours on the approved drawing on the left. It doesn't quite come out on the proposed on the right, but the property doesn't face directly towards the neighbours. It's set at an angle. If anything, this is a slightly better relationship than the approved scheme in the officer's view. Moving further round, within the building, within the development, there was a terrace of properties. Those terraces were originally stepped to account for levels changes. The proposal now removes that step so that these buildings here now keep the same ground level as the main terrace. The effect of that is that there are 40-centimetre increase in the ultimate roof height. But bearing in mind the significant spacing with the existing properties to the rear, boundary treatments, again, we don't consider that that has any adverse impact on amenity. They haven't moved any closer, so the relationship with the neighbours is the same. The only difference is the ridge of the tiled roof will be 40 centimetres higher, but over that distance, we don't believe that's a perceivable change. The appearance is exactly the same. The footprint is exactly the same. As you can see on these drawings, it'll just be, that step isn't the degree of change. That was already there. It's a very tiny degree of change on these drawings. And the final property where there is an alteration, firstly, there's a substation appearing at the end of that cul-de-sac head, well away from adjacent properties. This is Roundwell coming down here. The approved layout shows a building at an angle to the access. The proposal simply turns it to face more directly on. As you can see here, in effect, it looks away from neighbours in terms of its principal front and rear elevations, and it's slightly further away from the boundary. On that basis, again, we feel that there is no adverse impact from this change. And on that basis, officers recommend that members grant permission for the Section 73 alteration. There is one proposed urgent update, Condition 8. This is simply to reflect the updated drawings. I should say, going back to plot 25, which has been the subject of a number of neighbour objections. Originally, the applicant proposed to move that building much closer to the boundary with the neighbours, but following the receipt of objections from the neighbours, we asked that the building move further back to its original position. So I think the net difference between the approved and the now proposed is about 1.2 metres. So in terms of the wider relationship, it's not material. So in effect, the scheme that you're seeing here has sought to address a number of the objections that are in the officer's report. And again, with the minor amendment to the drawing to reflect this revised building position, we recommend that permission be granted.
Thank you, Mr. Mackey. As members have been told, there is that small urgent update. Can I take declarations of lobbying at this point? Right. Turn to the first speaker on this application, Mr. Flisher, for the applicant, please.
Thank you for the opportunity to respond on behalf of the applicant. I'd just like to highlight 3 points for members to note this evening, please. Firstly, this site is already allocated for new homes in your local plan, and this committee has already granted planning permission for the development of the site. Therefore, all the main issues around the proposal have already been agreed and are not for determination this evening. This application is only focused on the proposed minor amendments to the plans. These amendments are intended to improve the details of the scheme and have arisen through the delivery stage of the project. The layout changes have in large part actually been required of the applicant through the technical approval process with Southern Water for the diversion and sewer connection works. This has resulted in changes to the roads within the development to accommodate the required drainage. The biggest visible change is that the layout in the central part of the site has now changed from 2 cul-de-sacs to a small loop arrangement. This change would also improve access for delivery vans and refuse vehicles. It only affects the interior of the site, not its relationship with its surroundings. Moreover, KCC has confirmed that in highways terms it would be acceptable. Secondly, in formulating this application, we've tried to go about things in the right way. We undertook a proper pre-application process with your officers, which shaped the application as originally submitted. But we did not stop there. After the application attracted comments from neighbours, further changes were made. These include the redesign of Plot 27 in order to avoid increased proximity to neighbours on Sutton Street, reversion to the previously approved details for Plot 25, including for the same reason, and also revised house types for Plot 19 in order to address detailed design comments. Just to pick up a couple of points raised by the Parish Council, in terms of height, the Parish Council's response to the application raised a particular issue around the height of Plot 25. This has been fully addressed through the reversion to the previously approved design for this plot. The committee report also confirms that the minor changes in height on plots 31 to 39 would not be discernible from outside the site. Also, in terms of materials, no change to the quality of materials is proposed. The existing planning permission already controls the selection of materials by planning condition. This continues to be a very well-designed and attractive proposal. The changes are minor in nature. They would also improve the delivery of the previously permitted development. So thank you again, and I hope you're able to grant consent in accordance with the officer's recommendation this evening. Thank you very much.
Thank you. Turn now to Councillor Mrs. Springett.
Good evening, members. I'm probably going to move away from my speech, so timing has gone out the window. The application is described as very minor amendments. The problem is this application was first submitted in 2014. It's been through 5 different planning officers, so a lot of things that were agreed and chatted about have just gone. We had meetings with the original owner, with ward members and committee members, and a lot of things were discussed and verbally agreed. And now, again, that's gone out the window. My concern is there's been so many changes, so many amendments to amend things back to what they were in the first place, that actually even I'm not sure as to which documents are current. So my main concern is I would like a deferment just to give us a little bit of time, and I'm happy to work with Mr. Fisher if he'd like to come to a meeting with myself and some of you, and we can just run through things. That would be absolutely fabulous. Plot 25, I'm still not happy how close it is to Sutton House, which is a Grade 2 listed building. I would like that to go back to where it was. There's been a question raised with me today by a resident as to whether it's gone to exactly what was originally designed, or whether there's the same materials, or I think it's going back to a barn design. So again, there's a confusion about what final documents we're having. I've got a question on plot 43. Mr. Fisher might be able to answer this. It appears from the documents that it's turned round, because it looks like there's no path now to the front, and the street scene that's part of the original approved application had the front of the property facing Roundwell. So you have a complete street scene, which was one of the approved documents, and it looks to me like it's turned round. So now, instead of looking at the front of the house from Roundwell, you'll look at a fence of 1.8 metres. So that needs a bit of clarification, so that would tie in with my request for deferment, just so we can clarify whether or not that's happened. There's now an electricity substation in that street scene, fully visible from Roundwell, which again moves away from the original approved street scene document, and there's been no change or amendment to that street scene. So I do have concerns on that. The site is really sensitive. We would like to, you know, residents would like to work with the applicant. I did phone them and they were supposed to phone me back and never did. So again, Mr. Fisher, I would welcome some communication, because I think we can resolve all the issues. My final request, originally we should have had a delivery committee on this development, but I think Mr. Bailey will confirm it accidentally got left off the original grant of permission. I've got that in an email, by the way. So could we please have a delivery committee, so an informative for a delivery committee, which will enable ward members to work with the applicant to hopefully make this development come forward very smoothly. Thank you very much.
Thank you, Councillor Spring. Correct me if I get this wrong, Mr. Mackey, but what I think we've got is essentially a request for a stock take of what the existing consents amount to, which is one issue, and which I imagine we could probably do, but wouldn't necessarily require a deferment, provided, my second question, I suppose, that's linked to that, is that nothing in this application in and of itself prejudices any of the previous applications, because obviously if it did, then we'd have to defer.
Chair, the original permission that this is a variation to was a detailed planning permission, so the layout of all the properties is as per the drawing that we started with, this drawing. These are the proposed changes. You can see all of the elements not in red are exactly as per the approved scheme. So in our view, it's very clear what the changes are, and they are those relatively minor alterations that we've described to the footprint or alignment of the properties. It doesn't change any of the fundamental principles, such as the open space and the other open areas associated with the site. Just to sort of address the front, this is the main sort of Roundwell street frontage, and Sutton Street comes along here. The site is accessed off Cross Keys. So in relation to Cross Keys, absolutely no material change. The change in the relationship to Sutton Street is as we've run through in the presentation. To go to plot 43, on the left is the approved relationship. This is the front door of the house. So in a way, the house was actually inward looking. It stared at its garage for obvious reasons. I guess the owner would park there and you can see the path to the front door. All that's happening is it's turning 45 degrees to arguably a better relationship. So when you come along this cul-de-sac, you approach the front of a building rather than the side. And as we've discussed on many other schemes, sides often include fences and blank frontages. So this, we feel, is an improved relationship. In terms of the relationship to Roundwell, as approved, it would have been the sort of back corner of the building. As proposed, it's the rear of arguably a more articulated building with a little bit more detail than before. So I don't think the relationship to Roundwell changes in any material way. The substation is a new element in this part of the site, but as a structure, it's no different, probably smaller than the garages. So we don't feel that that fundamentally changes the character of this part of the site either. So there would have been a garden boundary. There is a garden boundary. There's no material change to Roundwell, nothing that I feel needs re-examination. It's an alteration to an approved scheme. Yes, there have been lots of conditions in between, but there haven't been a series of planning applications that should necessarily cause confusion.
Okay, well, it's clear from that officer's view is that this doesn't in itself change any of the approved schemes, so it would be difficult to justify a deferral. Gentlemen, if you wouldn't mind. However, outside of this process, it would be helpful if we could just enumerate at some point the actual overall position for the benefit of the Bearsted Parish Council and the members in that ward, so everyone is clear on what exactly has been approved, what conditions apply and everything else as a result of the number of applications on the site, because not necessarily as part of this process, but at some point, so that everyone knows what has been implemented, what is supposed to be implemented, etc., etc. That would be useful. Now, Councillor Spooner, you're one of the other ward members, and I'm sorry I came in first, but there were some procedural questions.
Thank you, Mr. Chairman. I think we've always known that this site will be horrendously difficult to develop because of the extensive drainage, flood attenuation and highway works which will be needed, and this is still serious. Oh, I'm sorry. Okay, I'll start again. Sorry about that. We've always known that this site will be horrendously difficult to develop because of the substantial drainage, flood attenuation, highway works were all essential prerequisites to the development being carried out, and these are still very, very much in the minds of local residents who are really scared of what could happen on this site. There are also issues, I think, about the ownership and the funding in perpetuity of the proposed local nature reserve, and we've heard little about that this evening. It's taken 3 years to get where we are now, and we still haven't had the flood drainage works. We still haven't had, which is of great concern to local residents. But I appreciate this is a Section 73 application. All we're looking at is the changes to street scene, amended layouts, and quite straightforward, or should be quite straightforward issues. I do have 3 concerns about the layout. Firstly, on plot 43, where Mr. Mackey has been explaining things to us. I personally think that plot 43 needs to be reorientated so it actually faces onto Roundwell. I think that would look better. I'd like to pick up what Councillor Springett was saying. At the moment, as you come along Roundwell, you will just see, as proposed, a 1.8 metre fence. I think it will be far better to have the house facing onto Roundwell so that house can then have an enclosed private rear garden, and the fence will then be along the access road rather than facing out onto Roundwell. That is just my own sort of personal preference. With regard to plot 27, I'm wondering if I'm actually looking, I printed off some of these layouts, and I'm wondering if I've actually got the latest one, because the one you just showed up on the screen was a bit different. And my main concern about 27 was its proximity to the boundary of the properties in Sutton Street. But it seems to me that this has now been altered again, and I think the distance which you are now showing is far more acceptable. So I'm quite happy with that. On plot 25, I'm very pleased with the way this has been amended, but I'm having pressure from the resident of Sutton House, who is convinced, and I'm not quite certain what he means, he talks about a barn-style building. I think what he means by that is something with fully hipped roofs. I don't know. It would be useful if you could show the actual elevation of that one property so we can see exactly what it is that's proposed. Is that at all possible?
The officer hasn't provided.
Oh, okay.
But I can confirm that whilst the detail, you can see the detailed plan form of the building has changed
Yes.
slightly with these front and rear gables. The architectural style of the development and the materials used in each of the plots hasn't materially changed. The character of the development will look as it did before. So there isn't certainly the introduction of an incongruous architectural style in this property.
Okay, thank you. That then confirms that. So that is one...
I'm sorry, Councillor Springett, if you're going to talk that loudly, you're going to have to go outside. Thank you. Would you like to carry on, Councillor?
Yes, sure.
Now I can hear you.
That is one sort of work train, as it were. The second is the overall development that is taking place, and I think it will be very useful if the officers could compare a schedule, perhaps on an Excel spreadsheet, I don't know how high-tech we can be with this, showing all the conditions which have been imposed on all the previous permissions and approvals, and then indicating which have already been discharged and which haven't. It's just so we all know where we are. And I would also propose that we convene a delivery committee, which is something I think we should have had several years ago, but I think it got quietly forgotten about, be as it may, that has happened. I think a delivery committee will be very, very useful, together with the list of all the conditions, and then it will be possible then for local members, planning committee members, the applicants, to work together, and the officers to work together, because I think that is the best way forward. And I'm very impressed with what the developers have so far done to meet the concerns of local residents. It's very impressive, the scheme they have devised. I think it could be just made a little bit better. I don't think there's any doubt that this scheme will eventually get approved. I think we just need to make sure we've got it absolutely right before we do so. So I would like to propose that we defer just to sort out those issues, and secondly, that we have a delivery committee. Thank you, Mr. Chairman.
Councillor Spooner, I don't want to be difficult, but it would be quite possible to set out a schedule. In fact, that's more or less what I was asking for at the beginning, of what the conditions are and where we are with the discharge or non-discharge, and to look possibly at that issue again. However, this would need to be a separate resolution, because those 2 points are not really germane to this determination. So I think we would need a separate vote on that, because it really doesn't follow one from the other. On your main presentation, can I just clarify what points you're actually seeking to change? Because I wasn't clear on that. So could you just come back on that?
I think the only part of the layout now which I have concerns about is plot 43, which I would suggest should be reorientated round. So it faces, the front door faces due north, rather than facing due south, which it seems to be facing at the moment.
Chair, from an urban design perspective, this building does have two roles. It has a relationship with Roundwell and it has a relationship with the estate, so it has those challenges. I think we would place greater weight on the building's relationship with the estate that it forms part of. And it's still important that the elevation to Roundwell is attractive enough, but the approved scheme already has, let's call it, the back garden fence there already. So the proposed changes have no change on that, and it is a scheme that involves more landscaping on that boundary to help soften the impact. I think for the building to sort of turn its back on the street that it's part of wouldn't be a natural piece of design in terms of the estate layout, and I think on balance it's better that the building exists with its street and that it sort of sits close to you but doesn't dominate Roundwell, rather than it having an odd front back garden facing a street. The back door wouldn't be where the front door is, and it just wouldn't make sense in terms of the quality of occupation and the layout of the site. But I think we can, as we further engage with the applicant, make sure that we get a detail of treatment to Roundwell that makes sure it's an attractive streetscape from the established highway to the northeast.
Can we just check, because there seems to be some dispute as to whether this fence actually is there, and if it isn't, when you're talking about the detailed treatment, could we make sure it is?
I think some members are saying that they don't want a fence there, that they want some engagement with Roundwell, but either on the approved or the altered scheme, that's the back garden to a family dwelling, so you would expect a degree of privacy and security along that elevation.
Maybe I was wrong because, to take that view, but shows the perils of listening to people muttering in the audience or shouting in the audience, but there did seem to be some dispute when you said the fence was already there, so we can just check that.
Sorry, Chair, I wasn't suggesting a fence was there. I was simply saying that the boundary, the relationship to the street is what I meant to say.
Yeah, okay, but you did say the fence was there, so...
The boundary treatment has been discharged pursuant to conditions, so...
Okay, personally, you know, I don't think you could defer for the issues about which relate to previous applications. Personally, I think that it's pretty subjective as to whether or not the layout is better one way or the other, but we'll see what other people think as to whether that merits.
Just one further point, Mr. Chairman. I think that amongst the things we're still waiting for is a detailed plan of landscaping and boundary treatment. When that comes in, perhaps that could particularly address the situation with plot number 43.
Yes, hypothetically. That would be better than Austin.
Yeah, sorry, Chair. The boundary landscape details for the approved scheme have been discharged, but I think I'm happy to facilitate a meeting between the residents, the councillors and the developer to clarify where we are, to identify whether there are any improvements to, for example, the already approved boundary treatment that could be carried forward into this scheme. I don't think it would be appropriate to defer the application for that reason, but I'm more than happy to ensure that from this point onwards there is clarity to the residents on what is going to be developed, and if there are net improvements that we can sit down and effectively chair between the residents and the developer matters such as landscaping or other detailed elements that you would like to see addressed.
Well, given the helpfulness of the applicant so far, that does seem to be a fairly hopeful prospect. Councillor Spooner, and then we'll take anyone else who wishes to. Would that meet your?
I'm fine with that, thank you.
Okay, now Councillor Atkinson.
Yeah, thank you, Mr. Chairman. Councillor Spooner mentioned, I think, plots 25, 27 and 43, which seem to impinge on existing properties. So I just wonder if we could maybe remove the permitted development rights just from those properties so they don't impinge any further. That's my first point. And my second point is related to condition, 21 on here, about swift and bat boxes. I was reading the other day that there's about 250 species of bee in this country, most of which are solitary, and you can actually install bee bricks for solitary species. And I wonder if we should maybe consider installing bee bricks in these sorts of buildings for solitary bees. Is it something we can put in now, or do we need to change our planning policies? It's something I think we should be thinking about anyway. So I'd like to propose that we have bee bricks installed in the buildings which are still to be put up. Thank you.
I think some consultation is going on about particular conditions. On the first point, the sound quality is quite bad in here, so you may not have picked up on it this evening, that the original layout did impinge, 25 did impinge quite severely on the neighbouring property, and the parish council and others objected, and it's more or less been moved back to where it was. So you may not have caught that because the sound quality is not excellent with the microphones this evening. On the second point, we'll come back to that and we'll take any other further points. Councillor Mumford and then Councillor Parfitt-Reid.
Well, I'm listening to this debate, I'm listening to the speakers, and what seems to me is that there's an awful lot of confusion on the impact of what's going to happen. There's been offers of meetings between the developer and the ward councillor, and that's been backed up by the officer. I really want to know if tonight we were to defer it. I think we'd come back if we deferred it for one cycle, just for democratic reasons, that the people who are going to be affected get to clarify what is happening. So what would be the impact? I know you're saying to the officers, don't agree with me, but I'm asking the officers, not yourself. What would be the impact if we deferred it for one cycle to allow these meetings to take place and clarity would prevail?
Chair, to respond to that, I mean, no, I'll give you my response to your question, don't worry about that. The objectors, from what I can see, clearly understand the relationship of the development to their properties and have made comments about what they perceive as potential impacts. So I don't see that a deferral for a chat and clarification, an invitation to update their comments would necessarily change their views. To me, the application's clear. It's a detailed permission. Lots of the conditions have been discharged, and these are some minor tweaks. But I appreciate a resident doesn't live with a planning application in the way that officers do, and that they might have fallen behind the details that have been approved. But I think in terms of what we're asking you to consider tonight, which are some alterations to an already approved scheme, I don't think as a committee group you would necessarily gain anything from a deferral. I think residents have made a number of very detailed comments that focus in on the changes, and we've been able to assess those. And as we've highlighted in the presentation, 2 of the properties have reverted back to where they were as a result of the feedback from residents. So I don't see that we as officers would seek further changes as a result of an additional conversation.
Does that answer your question?
My question was, what would be the impact of deferring it one cycle? And I'm not sure I got the answer to that question.
I think the officer gave the same answer I did. Nothing at all. Councillor Parfitt.
Thank you, Mr. Chairman. I want to sort of move away from the plots and the layout. My concern is more to do with this substation that has appeared, because I do think suddenly putting a substation on a road is a major change, and there are health impacts to that, and I think I'd like some answers to that as to why. Oh, sorry.
To be perfectly honest to members, I can't tell you where the substation was in the original approval, if there was one, but the position of the substation as proposed within this scheme is here. It's some distance from the public highway, and there will be a material amount of landscaping and vegetation between it and the established public highway. I don't think on that basis there would be any significant effect. It's not unusual in modern developments to have substations at the end of cul-de-sacs or between properties. So we are comfortable that in streetscape terms within the development, it won't harm the amenity of the future occupiers. It's situated away from any existing residents. So the real question is whether that distance from the road is acceptable or not. I see no harm arising from that quite substantial distance between the back edge of the pavement on Roundwell and the proposed position of the substation.
But do you think it would alter the objections?
Well, the substation has been part of the application that we've consulted the residents on. It's not an introduction the residents wouldn't have seen before. This has always been part of the application that went out for consultation.
But you said you didn't know where it had come from.
Councillor Wilby.
Thanks, Chairman. Just kind of a quick question. Obviously, we're going over a lot of the landscaping stuff, which we haven't actually got the detail of. Would it be possible to say we approve the changing on the spinning of these properties, and that the landscaping scheme, if go to the delivery group with the ward members, and if it's not agreed by the ward members, it then comes back to this committee? Is that doable?
Chair, there is a solution to members' concerns about the substation and the detail of landscaping, in that because this is effectively a fresh permission, where conditions have been discharged, the new permission inherits those details. But as Mr. Bailey's kindly pointed out, you could, for example, condition 13, amend that proposed condition to require additional elements of landscaping in relation to, for example, the substation, or any other elements that you may have valid concerns on. So it is possible to ask for fresh mitigation to deal with the changes for the scheme.
That would seem sensible.
Yeah, I think we need those landscaping schemes for all the changes that have actually happened, to come, not just the substation, because some of these houses, I know some are just slightly tweaked, but some have changed completely. So the landscaping would change completely for that. So I think that the condition would have to apply to all of them, not just the substation, if that's possible.
Yeah, I think you were open to that prospect, weren't you? Yeah.
And in that case, I'd like to propose what's on the papers with that amendment then.
Councillor Harwood.
Thank you, Chairman. Just some observations, really. I am a little bit concerned that the proposed revised road layout is quite urbanising. It's a very traditional urban estate when this development sought to engender more kind of sense of place. And I'm a bit concerned that we're going to, you know, the little Scalextrics, the kind of circular route, is a bit grim to my mind in terms of an internal estate road. And I understand the utilitarian issues of dust carts and the Amazon delivery lorries and whatever, but I do think it's a little bit sad that if you like, the design conceit that was used, which was to create enclaves within the development, has been lost. I think that's one thing. But that said, the most bonkers thing about this scheme is the access road. I mean, why we've got to have this over-engineered, gargantuan, bridged road over the Lilk meadow, onto an already very congested access onto Roundwell. I just don't understand. There is no technical reason to my mind on this. There's certainly not the safety argument that was proposed. I just don't get, and I don't get any of it. And yeah, anyway, the less said, I think, on the access. But moving on from that, in terms of the delivery group that was established on the original planning permission was only, in terms of its terms of reference, concerned with the nature reserve in the Lilk Meadow and Carr. And that's the concern, I think, which was kind of picked up by local residents. I think it is going to be vital as we move forward in terms of any practical issues which arise, that we have got that sounding board with the parish council and with local members and so on. So I do know that. So I think that's an area where, when we look at the schedule of changes and the schedule of permissions, we do need to get our head around what the delivery board actually comprises. And meetings have taken place, but they stuck very rigidly to the nature reserve issue, and actually some of the more development orientated things kind of slipped into the discussion, but they were not the kind of be all and end all as to why the meeting was taking place. Just finally, the point that's been raised on a number of sides of the chamber regarding the landscaping scheme. Yes, the landscaping scheme is approved. Yes, it's very good. Yes, the boundary treatments are very good. However, the layout is changing. That does have impact. There is the kind of ditch that runs through it, which goes through culverts and so on, which is going to be affected by the change in the layout. There is the substation, which is a material change on a sensitive part of the site. So I think Mr. Bailey's suggestion that we need to somehow reference the fact that the landscaping scheme needs to be revisited and tweaked does need to be captured, and hopefully that has in what has been moved. So I think you know, with all those taken into account, I can live with the road. I don't like it, but then again, I don't like any of that road layout. Thank you.
Right, okay. It's been moved and seconded that a motion has been moved to approve the application with the additional, hang on, I haven't finished yet. That with the additional condition of the regarding landscaping. Now, Councillor Atkinson is doubtless about to remind us that he raised a point about ecology in specific relation to bees, and officers, I think, were looking at what the existing conditions. Is there any way you could incorporate that if we so choose? Yeah, well, a few fried bees, but that could be quite interesting. But if you wanted an interruption to the power supply, but
Chair, as Mr Bailey's pointed out, condition 21 dealt with swift and bat boxes. We could amend that to require not only those details again, but also similar measures relating to solitary bees, if that's what you're seeking.
I really don't see it does any harm, so we can have a look at it and see whether we can deliver something. Councillor Atkinson, I think that addresses the point. So only speak if you don't think it does.
It does answer my point,
yeah.
so thank you.
Right, and so I now propose to move to a vote unless anyone has any questions about... No, that's not part of this discussion. A delivery group is not part of this determination. We will return to that in a separate matter in a minute. Yes, and I would direct members' attention to the urgent update, which has to be included in the recommendation as well. Councillor Kimantz, are you adding something to the recommendation or taking it away or whatever?
No, I just wanted to ask a question. In the discussion when Councillor Harwood said about the scale electric set, I must admit I'm in exactly the same view with that. And you said that there was advised by the officers to change it from cul-de-sacs to this scale electric set. Is that correct?
Chair, from an urban design and placemaking point of view, I entirely agree with Councillor Harwood. Planning officers don't like highway engineers getting to schemes first because they design vehicular routes rather than places. It wasn't the planning officers that advised that the layout should be changed. As the applicant said, they took advice in relation to the impact of the surface water drainage solution and foul drainage. There were also comments put in by the council's refuse team that following risk assessments, they are trying to engineer schemes to reduce risk to pedestrians and cyclists from reversing vehicles. So I suppose what we're saying is that there were drainage and highways engineering recommendations for that loop, not planning recommendations. It doesn't contribute to placemaking, but we don't feel that, having regard to the scheme as a whole, we could refuse it because it's a basic loop rather than attractive cul-de-sacs. Does that make sense?
Briefly.
Yeah, just briefly, but for the size of it, we just need to employ some bin men that actually walk down the street and drag them on the wheels that they're designed to be dragged on.
I wouldn't disagree with you, Councillor. Right, we're clear where we are now. Okay. In that case, I'll put the amended recommendation to the vote. Those in favour, please indicate. Those against? Abstentions? Thank you. Right, now, separately, members and parish council and visiting members have discussed issues. Officers have offered to facilitate a meeting to ensure and also draw up a table so that everyone knows where we are with all the applications and also to ensure what the delivery group isn't supposed to be doing, because there has been a grey area about that to a certain extent, and update us on where we're going with all of those things. Now, that obviously couldn't be incorporated in the decision itself, but our members agree that's the right path forward. I really do need to hear one way or the other. Thank you. Right, we'll now take our 15-minute tea break. Ladies and gentlemen, if you could be taking your seats. Anyone not back here in 60 seconds won't be taking part in the discussion. Right, ladies and gentlemen, direct your attention to item 14, page 29, Hen and Duckhurst Farm, Marden Road.
Thank you, Chair. This is another Section 73 application, but in this instance, the proposal is to amend a single condition relating to the hours of work undertaken on the site. This is a site plan showing the layout of the approved development. What members should note in particular is the existing residential community that fronts Marden Road on both sides of the site access and all the way up the north-south eastern side of the site. These are properties situated very close to the site boundaries, and as you can see, it's a significant development. Unlike the previous application, there is considerable activity on site. The development is well underway. The site access has been constructed and the plots are progressing at a pace. These are pictures I took when I visited the site earlier this week. It's fair to say that there was a constant stream of vehicles of all sizes entering and leaving the site. You may have noted in some of the objections that reference has been made to the inadequacy of street cleaning, for example. I watched this vehicle clean the road outside the site, and moments later a lorry left the site and it was back to where it was. So it is quite clearly an intensive operation. The application before you seeks to amend the existing permission condition relating to hours of work. Or I should say amend the condition. It seeks a parallel permission with variations to that condition. The current permission allows 8 a.m. to 6 p.m. Monday to Friday, 9 a.m. to 1 o'clock on Saturdays, no working Sunday or bank holiday. The applicant sought to amend that to increase the start, to bring forward the start time on a Saturday to 8 o'clock. The planning officers, when we assess a Section 73 application, have a duty not to simply consider the amendment to the condition, but to review whether that condition satisfies the tests. So we have to have regard to the 6 tests, which you're all familiar with from your training. 2 of those tests are whether the condition is necessary to make the development acceptable and whether it's relevant to planning. We also have to have regard to guidance in, for example, the National Planning Policy Guidance Statement, and that, as you will know from training, indicates that planning conditions should not duplicate other legislation, and the MPBG specifically emphasises the Environmental Protection Act. The Environmental Protection Act is that which deals principally with matters such as noise, dust, disruption and disturbance. In considering whether a condition should be retained or not, we also have to regard to whether the other measures would be effective. In other words, if we were to drop the planning condition for planning reasons, do we still have sufficient control under other legislation to protect the amenity of residents? The Council has, jointly with Tunbridge Wells and Swale, a document called the Environmental Code of Development Practice. That document sets out matters such as our policy on working hours and noise. And we require developers to adhere to that under the Noise and Control of Pollution Act. On that basis, under the Control of Pollution Act, we can ensure, or we can require the developer to adhere to the same time limits that in effect the planning permission seeks to duplicate. Now, I can appreciate the frustration of the ward councillors and the residents because this is a development that has breached the planning condition. We don't dispute that fact, and I believe, unfortunately, last weekend, the week before committee, they worked on the Saturday and the Sunday. We questioned the applicant as to why they were carrying works beyond approved hours, and we've had answers, and residents have had answers, and sometimes there's a difference between the two. But the applicant accepted that they carried out intensive works this weekend, including construction of roads, with no reason other than effectively development timing. So there has been a breach of the condition. We do accept that there are potentially unacceptable conditions taking place. What officers are in effect advising is that it isn't, the planning condition is not the most effective way of achieving enforcement of this site, that the Control of Pollution Act would be a potentially more effective way of pursuing the developer and seeking conditions that respect the residents' amenity. So in effect, under the Control of Pollution Act, having regard to this guidance, we can require the developer through a notice to accord with hours of use, to respond to particular noise levels that we set, to have particular measures about equipment and dust control measures, so measures that go far beyond a planning condition that simply has start and stop times, because these measures would control matters such as noise and dust, not only outside hours, but within the approved hours as well. So the view of officers is that under the planning tests, we can't justify the condition being retained, but we believe there are alternative measures that committee could rely upon in terms of this council enforcing against any future breaches. The applicant has acknowledged to us that there have been some shortcomings in terms of their behaviour and their relationship with neighbours. They have suggested that they would accept a deferral of the planning application in order to engage with the parish council residents and ward councillors. As planning officers, we can't recommend that. There is no planning reason for that, but committee may want to consider whether deferral for better dialogue before the condition comes back is an issue that you might consider. There are a number of options available to members today. You can accept the officer's recommendation and remove the condition in its entirety, and in doing so we would effectively pass the request to the Environmental Protection Team to pick up the baton in terms of the Noise and Control of Pollution Act. You could refuse the application because you find the condition or the additional hour unacceptable. The other alternative is that you approve the applicant's request to retain the condition with the additional hour working, but in doing so you would have to identify the reasons why you felt the planning condition should be retained. The courts have considered this issue of duplication between different planning and legislation controls and have always advised that there must be unique circumstances to a site that justify a planning condition going above or duplicating other legislation. So those are three potential options that, well, four, including deferral. There is further information on the legislative controls under the other acts that are not in the officer report that we could provide in the updated report following a deferral. But those are the choices that members have today. Determine as per the officer's recommendation, consider whether you feel the condition as requested by the applicant is appropriate and why, refuse the extra hour or defer to allow further consideration.
I'm minded to But before we do anything else, even hear from the speakers this evening, we should examine option 4 on a slightly tweaked basis. Defer for further consideration and discussion, not just with the applicant, but separately internal dialogue within the council, whether we actually believe that an alternative method of control actually exists. Because we need to know, as a local authority, what method of control is likely to work before we amend the planning consent. Therefore, yes, by all means, let's have dialogue, but at the same time, internally, our officers here need to sit down with environmental health enforcement and discuss what is and is not possible, and then we need to come back. So before, I'm terribly sorry to the speakers, having come to it, but no, it's no point if we're going to defer. No, you are not able to speak at this point. And if you continue, you will be leaving the room. The fact of the matter is, I'm not going to have a debate this evening if members are minded to have that discussion. If members are not, we will hear and we'll make a determination which may not be the best determination. But I'm not going to have nearly half an hour of discussion which members will doubtless wish to come in on after speakers and then go away and come back again. So, Councillor Parfitt-Reid.
Sorry, I just do feel that if people have made an effort to come here, they should be allowed to speak.
I'll put it to the committee, but there is no point, in my view, if we're going to defer, because you'll only have to make, you'll be making a speech to something we're not going to be determining this evening. No, so I'm not going to have a debate. If you want a discussion, go outside and have a discussion with the relevant member. Councillor Kimmans, did you indicate? Okay, I am going to formally propose from the chair and look for a seconder to defer for discussion item 4, including dialogue and also an internal debate whether of which method of enforcement could be used. Those members in favour?
Agenda item 14, Chair.
Yes. Those against? Any abstentions? So decided.
If I may, just for the benefit of members of the public, the item will be coming back before committee, and you will be able to speak when it comes back. Please rest assured.
I'm sorry, but if we introduce it, we're at risk of determining it tonight, and we mustn't, in my view, do. No. Okay, thank you very much, Mr. Bowden. I sort of assumed that would be the case. So, thank you for being so reasonable. I'm sorry you've had to come out. Right, we move on to Goldstone Walk, Boxley, Chatham, item 17, page 95.
Can I just make it noted that I was totally in agreement with what you've just done?
Onwards to item 17.
Thank you, Chairman. This is an application for the erection of one detached 3-bedroom house with a garage and parking. I'm just going to take you to the aerial view because I think that gives you the best view of the site. So this is number 22, number 16 and 17 here. This is the application site here, which is the side garden of number 22. And as you'll see, looking at the spacing of the site, it does look rather odd why it wasn't developed in the first place for housing, one may assume. But if you look at the planning history on page 96 of your report, you will see that it appears that the this area of land was incorporated is to enlarge residential curtilage, which effectively explains why it became the side garden of this house, because no other houses in this estate have a garden of that size. I would also point out on the top of that planning history, application 15-500-349, to which an outline application was granted for a 3-bedroom dwelling with all matters reserved for future consideration. And that is quite important, and I'll show you that plan in a later date. Now, whilst that application is time expired and obviously wasn't considered under the current local plan, members did approve at this planning committee in October 2015 that scheme, which effectively assessed the general principles which still apply now about development with an infill development within a substantially built up area and within an urban boundary. So the same principles apply to this scheme as did apply to the now time-lapsed outline planning permission, albeit you are considering it under new policy regimes. But it is important that, you know, historically and previously it's had a planning permission. So in terms of that's the aerial photograph, and I'll just take you through the application. I do apologise. Again, so this is the view from Impton Lane. So this is number 22. These are the trees that are within the site, and this is its existing boundary fencing. Now this is the view from Goldston Walk. Effectively, this is Goldston Walk here, and this view is looking at this access here. This is the current access serving these two properties, and the proposed access effectively puts an access way from this road across this area here. Now, under the previous permission that was granted in 2015, access was taken from effectively number 22. It proposed to demolish that garage and have an access way coming down here. And in reality, that's what's changed with that application to this application, in the sense that they're coming off this access here. So that's access number 16, 17, and the new access would be proposed off this area here. I mean, obviously that's the existing side boundary, so the new access would come off down here and go off down here. It wouldn't impact on these trees, which are within the application site. Oh. Again, just view looking over to number 16 and 17 with this is the garage of number 22. Number 22's here, so the application site is just off to the left here, off picture. This is the garden area, so the new access would come in approximately this position here. These are the trees that you see in the context of the street scene that would be retained. And this is number 22, Goldston Walk. So as I said previously, the former access under that 2015 permission came in through here. It knocked the garage down and then went into the site. And now that access has been switched around. And I'll show you those plans as we move on. So this is the proposed planning unit here. This is the application site. It retains sort of an extra piece of land from the previous grant of approval. This is the proposed layout plan with the access, the dwelling, sort of a separation distance gained from number 22 here. And in terms of where you've got your principal elevation, you've got your principal elevation here, and obviously the side garden, access to the side garden here. So in terms of elevations and how it looks, you've got an internal arrangement, 3 bedrooms, study on the first floor, and then a sort of an open plan living area here with garage parking. This looks into the side garden. This is looking towards number 22, and you'll notice obscure glazed fit shut windows, and this is the front elevation from here. And you've obviously got a flank elevation with the reduced profile from the garage. So this is effectively the elevation that would face the street. And just for member information, this was the application that was approved under 15-500-349 500-349 as the outline application. Again, all matters were reserved for future consideration. This was kind of an illustrative layout, but that was approved by this committee in November 2015. And you did see previously this is where the access came in. So in terms of footprints, it's similar in footprint to currently as now proposed. And there were some illustrative elevations which were not dissimilar to the ones proposed, but obviously they weren't considered by that committee. So in terms of general view, I don't intend to go through the report. I think the report is self-explanatory. In terms of proposals, look at brick and tile hanging to the walls and to the roof. In terms of principles, policy generally seeks to support infill development within existing urban areas, which is such like as this. You would have seen that this is not a part of the established character in terms of such a large garden area within the existing estate. I would say it's the abnormal part, and therefore the principle of development that was previously established, whilst that has time expired, is still relevant to members' consideration now, albeit it was under a previous local plan. In terms of overlooking issues, you can see the distance. It's considered adequate separation distances from the surrounding properties. In terms of the direct impact on number 22, you'll see that that's been addressed by these windows which are fixed shut and obscure glazed up to a 1.7 metre high level from floor level. So that will stop direct into looking into the garden area of number 22. And the distances around from surrounding properties is acceptable without harming residential amenity. So taking all the above into account and the relevant development plan policies, the proposals do comply with the development plan, and in accordance with the NPPF, planning permission should be granted on that basis. And you would have had a list of conditions that are set out on page 104, 105 and 106 of your report. So on that basis, the application is recommended for approval. Thank you, Mr. Chairman.
Thank you, Mr. Bailey, for that thorough introduction. Can I take declarations of lobbying, please? Just the two of us. Right, thank you. Right, there's no urgent update on this one. So we go immediately to Councillor Hinder. Thank you for your patience this evening.
Thank you. You may be a little puzzled then why a Boxley Parish Council and myself as a ward member objecting to this. I would like you all to really study page 95, which is the plan of the area, because we have no objections to the building itself. We understand why the applicant has not proceeded with the approval granted in 2015. But there is one major problem here that we feel you should be aware of. And that is that this proposed development is down the side of a footpath. And the road, Goldstone Road, stops before this proposed property. And all there is a turning circle. And when we looked carefully at this, one is left with the question, how can this developer, proposed development, gain access to the development? The only way in which it can be done is by perhaps removing the public footpath. Now, this public footpath is extremely well used. It serves 7 roads in the area that all, and the site is developed in such a way that the pedestrians come up through this to Impton Lane, which is the main route through, and where the bus stops are. So it is not a public access that is not very much used, it is used a lot. And all we can work out is that if you allow this development, ask yourselves the question, how will the developer get access into it? And you have a proposal on the conditions that may overcome this. We would urge that to allow traffic to come up onto and out of onto that public footpath, you are going to put people, especially children, at risk. Is that a risk you want to take? Conditions 6 and 7 on your papers, members, addresses this as to what the applicant may need to do to overcome this. But our concern tonight is to bring this to your attention. We have no objection to the actual proposed development. What we have strong objections to is how they get into the site. Thank you.
I don't normally ask a visiting member to clarify, but are you asking for an amendment to the condition or not? I wasn't clear from that. Sorry, Councillor Hinder. I'm going to give you 10 seconds extra because I think I need to know.
Thank you so much. What we're asking for is members to consider carefully that conditions 6 and 7 in particular. And somehow, if you grant permission to go ahead, whether those two conditions need reinforcing to ensure that adequate steps are taken with regard to creating an access before building development takes place on the site.
Thank you. I think we got that. Wait, right. Mr. Bailey, are we aware whether this footpath appears on the definitive footpath map or not? Councillor Harwood may know, but if you don't.
I haven't got the definitive footpath map in front of me, but it's a tar-macadam road, so it's maintainable. It is maintained. It doesn't look like it's unmaintained, so it looks like it's maintained, and I suspect it's maintained at KCC standard. But notwithstanding that, I think there are a couple of issues that possibly I need to raise in this point by just checking the owner's certificate in terms of the application, which may lead to a recommendation coming from me on the basis that the owner has signed certificate A, that he is the owner of all the land within the red line boundary, which is fine, but obviously he's going to have to, what looks like to me, extend the public highway. Now, in most instances, you wouldn't serve notice on KCC because they're a public body, just like you know, if it's a publicly adopted road, you wouldn't need to serve a certificate, what we call a certificate B notification on KCC for public highways. But it adds doubt to my mind on the issue that effectively can the applicant, I mean, I'm not sure whether KCC own this stretch of land that you can see in the photographs, because obviously you can see the bell mouth here, and the applicant is going to have to extend this bit of highway, which looks like it's probably publicly adopted, but I don't know, would have to extend that across there and then come in across the public footpath. Now, that's perfectly common, so it's perfectly doable, and it happens in every scenario in the street. But what I'm not certain to members, and I appreciate you need up-to-date and correct information, as to whether or who owns this particular piece of land to allow the applicant to extend that road and go right. So effectively where I'm going with this is that I think my recommendation probably has to be amended on the basis that I would recommend that the application be deferred for me to come back to you, and especially in terms of what Councillor Hinder said over there. There isn't a principal objection from the Parish Council, but I need to give members the assurance that the correct process has been followed in terms of the application. So, as it stands, I would recommend that this application be deferred for me to find out exactly who owns the land
and to be sure that the correct certificates have been served within the application. And if they have been, etc., then I'll bring it back to members with the assurance that the applicant can gain access to that site. And obviously I'll get some highway comments in terms of the crossing from that point. So that's as I stand. I don't think I should prolong it any further.
Councillor Harwood, I'm going to come to you just in case you actually know the answer to this, because you are fairly local to this.
Well, it is the alley, which is part of the estate and which is looked after by KCC. So what the extent of the ownership is in terms of the land flanking it, I think we do need to check out. However, I was, even without the public footpath issue, I felt that deferral was in order anyway, because I'm very concerned, and this is symptomatic actually of a malaise within the planning team, that this application has been dumbed down on the original outline we had on the site. Because you'll notice the drawings we had for the outline showed kind of solar panels on it and whatever, and we were wanting, you know, our normal features for wildlife, the bird bricks and so on in there. None of that is in these proposed conditions. We've not got the conditions on the gaps in the new fences which are going to have to go in to subdivide the garden. We've just missed all of them. And I come back to the point that for consistency's sake, why should a planning application that's down the road have all these conditions placed upon it, as is right, because it's supported by the MPPF, and then we have an application here which has even lost the conditions the original application that was approved by this committee had. I think, you know, in that time we've got from the deferral for checking out the land ownership, please, oh please, can we look at the renewable policy, the condition, and can we look at the integral niches for wildlife, and can we look at the standard one about the gaps under fences and so on, please?
Yes, well, I will second the deferral, but before, and we will then have the legal office to come in to see if there's anything needs to be added to that.
Thank you. Members, the Tarmacadam path will either be public footpath, in which case it will be on the definitive map, and it cannot be dug up or changed unless an application is made to have it diverted or stopped up. A diversion application can be made in sort of that flows together with the planning application to divert the public footpath off to some other location for the purposes of development. That application might get approved and it might not. It won't come to this committee. If it's not a public footpath on the definitive map, it might still be highway, and it might still be highway that's maintained by KCC, in which case, again, permission will need to be obtained before it could be interfered with. So I would concur with the other voices at this table that a deferral is the way forward. And I would suggest that we specifically check the definitive map and the highways terrier.
Yes, very quickly.
Yeah, I mean, it's just one point. If I could just, page 95 of your papers. I don't think it's a question necessarily of a stopping up or diversion, even if it is a public right-of-way, because if you look on that plan, my concern relates to the extension of that bellmouth, that road, and who owns that land right to the south of it to allow that road to be extended. Now, if that was in highways land, then clearly all you would do is you'd be crossing over, if it is a public footpath, which happens in many instances, across up and down every settled area. So it's not necessarily, in my view, whether it's the stopping up or diversion of that route, pedestrian access through the soup, because literally a car would just be crossing over, and obviously they'd have to have a Section 38 agreement or 278 to put proper measures in place for that crossing. It is the fact, has proper notice been served on the land issues that they're going to require, that I think is the crux of the point here. From my point of view, maybe different from the legal officer, but I don't see the stopping up as an issue here, because it's not going to stop it up, it will just cross over it.
Either way, permission from the Highways Department or KCC prowl, depending, is going to be needed, and we can't do that tonight. So deferral, plus the other points that Councillor Harwood made, and which I will second. I will just merely observe that although the committee can put these omissions right, my concern is what's happening with those applications that are being done by delegated authority, where if these conditions are not being applied, you know, we're not picking them up, James. So, you know.
Yeah, point taken. I'll raise that with the team. Can I just raise one point in terms of the renewables? As we've had many debate in this chamber, what I can do is ask the applicant whether they're prepared to put them on. But obviously, if they're not prepared to do that, I'll obviously then come back to you and feed what their response is. So I can't insist and we can't condition, as you're well aware, but I can certainly request that we put those on the elevations, just for clarity to members.
Yes, all I would say is that what I don't want to see is situations where they are on an application, and it has happened where officers, and I'm not talking about anyone here, has actually sort of encouraged the applicant to remove them because we don't have that policy position. We want to encourage it, and we don't want to discourage it, if I can emphasise, and I cannot emphasise that strongly enough, and it was on here and it isn't now, so if you see what I mean. Anyway, we have that motion, it's proposed seconded, those in favour? That's everyone, I think. Right, we move on to Gatland House. Unless anyone actually wants to speak to this, because it was called in, but Councillor Harper, who called it in, is not here. It is a simple update on the travel plan, and there is an urgent update. Does anyone wish to speak to this? Oh, for goodness sake. In that case, it will have to be introduced.
I just want to say briefly, I wonder
if you're going to say anything at all, then the officer will have to introduce it first.
It will be very brief.
Yeah.
Okay.
Particularly well, it's had 2 refusals at this planning committee. This just seeks to discharge the condition on the travel plan. You've got within front of you quite a detailed report which sets out what the travel plan contains. Kent Highways raised no objection to that travel plan. They are continually monitoring and updating the statistics that they get from the travel plan information. You've got an extract of what goes to the parents of the school. You know, what's in your report is just attached as appendix, is just an extract of what's contained within that travel plan. I think the school are working well to deliver modal shift changes, and they've actually seen, I think it's a 25% reduction of children brought to school as a result of their first travel plan that came forward, and they're seeking to improve it on a continual basis. So you will get further conditions coming back as a result of the 2 FE school, which they'll have to adapt the travel plan. But I think the school, from a shaky start, I'll be honest, are beginning to implement some very sustainable measures in this site. And as such, the recommendation of the condition is recommended to be approved.
Thank you very much. Now, there is an urgent update, very brief one on your papers. Can I take declarations of lobbying? No one? Look, no one? So, Councillor Atkinson, I'm sorry to have stopped you before, but it is procedure now.
Thank you, Mr. Chairman. Obviously, I entirely agree with what the officers said. I mean, they did have a shaky start, but they're actually engaging with the community now. But I have had complaints from people who live in Borough Drive, Sherborne Drive and Portsdown Close that parents park there. So, and then they bring their children through the alleyway from Sherborne through to Gatland Lane. So I wonder if we could maybe persuade the school to stop parents parking in those 3 roads. So that's all I need to say. Thank you.
Well, we can seek to use our best offices, so to speak, to encourage them to adhere to the travel plan, which does generally try to discourage that off-site parking in such a, shall we say, careless way. So, yes, I'm sure we can try and encourage better behaviour. Comments on this? In that case, all those in favour of the recommendation with the urgent update? Thank you very much, members. Right, we might turn now to the often vexed issue of member training. The report is on the papers, but I did wish to just make one minor, well, I don't think it is actually minor, but significant, in my view, amendment to that. Back in the day, and it was very useful, I think, to many of them, member training was quite often open to parish councils, particularly parish council members and the occasional clerk who are involved in the planning process. I mean, it would be particularly useful, firstly for practical reasons, because sometimes we have to run quite small groups with training with quite small groups of people, so it would actually make it more viable to do that. If we have some slightly bigger groups, and B, it would encourage better liaison between parishes and borough councillors and better understanding if we were actually having the same training at the same time for whichever level it is, basic training or somewhat more advanced training, which we have also provided at the same time with parishes for the more appropriate members. So I think the recommendations of the report are as they are, but it was the view of myself and the Vice Chairman and the officers when we discussed this at the pre-meeting that it should be training offered to both tiers of local government. Did you want to add anything, James?
No, I think the report's self-explanatory. I do agree with the Chairman on that basis. We did previously offer parish council training, and in this instance, members were to accept that recommendation. We would just invite the parish councils to those training events, obviously not replicating, so they had the opportunity to turn up or not if they so wished. And they did get valuable engagement from that, and I know there's been quite a change around of parish councils, councillors in their general remit, so I think it's good, but I think everything is set out in the report. I've tried to balance the member issues in terms of training and obviously in terms of the 2-year cycle for some of the core training requirements. We obviously have to balance it carefully in terms of the constitutional requirements, and the constitutional requirements are clearly set out. So I've had to try and balance what members have done previously, what you've previously agreed, and that's set out in the appendix in the minutes, and come up with a balanced training. Because I do understand, you know, there's lots of experienced members in this planning committee who've done the training on a regular basis. It's up for us officers to try and make it a bit more interesting, if we possibly can, but there are some key requirements, and that's what is set out in the report. So hopefully members will agree with what we've set out.
Any immediate questions, comments? No, in that case, I'll proceed to ask members to approve the amended recommendation with the additional points I made about parish involvement. Councillor Spoon.
Thank you, Mr. Chair. I just wanted to say how much I welcomed your invitation to the parishes. I think BSD Parish Council will be very happy to send 2 or 3 of its members along.
Hope we get the ones who really need it. All those in favour of the report? Thank you. In a moment we'll go on to look at appeal decisions, but before we do, I just want, so I don't forget at the end, I just want to make a public service announcement, I suppose. Councillor Mumford, myself and others have been batting for some time to actually implement something that was actually first brought out by former, well, he's still a councillor, but former Maidstone Borough Councillor Matt Bolton, who is now gone off to Tunbridge. We really should have got a transfer fee for that, but there you go. And in relation to money for conservation area appraisals and management plans, I'm delighted to report, as a result of the ongoing efforts of Councillor Mumford, Councillor Round and myself, at P&R last night, as a result of the business rates retention scheme money, a sum of £24,000 was allocated to conservation area appraisals and management plans to be written up and implemented. Congratulations to all members and officers for putting that proposal forward, which will be very helpful, I think, to the development control process going forward. It's not always we get good news stories at this committee, but I thought you'd like to know. So we turn to appeal decisions.
Sorry, yes, sorry. Caught me on the hop there. Councillor.
I think Mr Bailey's forgotten what a planning committee is like. It's so long since it's been here.
Yeah, in terms of appeals, I don't wish to draw particular attention to any particular appeal. I mean, obviously, there is the issue in terms of the Love Lane appeal. We haven't had, dare I say, the best of luck with our Gypsy and Traveller appeals, as members would have seen through the months coming through on Planning Committee. It is a difficult time in terms of defending those appeals, so that one is a particularly good decision. But right on the back of that, we just had the decision for the 10-acre appeal, which will be on your next month's appeal decision table, and unfortunately that one got lost on the public inquiry. So what I am endeavouring to do, and have committed to the Chair and Vice Chair, is to try to set out a report for the next Planning Committee, with both myself and Austin will be sort of inputting into and writing, trying to set out in terms of where our performance has been in appeals, because it has been hit. It's been hit quite severely from where we were previous financial year. Some of that is attributable to our G&T losses of appeals, but not all. There are sort of a mixed bag of officer delegations, some member overturns, but what I intend to do is set that out into a report and then try to come up with any themes that are coming forward on that basis. And, you know, are there any things that we need to be doing moving forward to make sure we can address that particular issue? So hopefully members will have some confidence that, you know, we're not hiding behind these figures. You'll get the full facts coming to you, hopefully, at the next Planning Committee. And if there are any recommendations arising from that, you'll also get those and to see if you agree with them as well. So overall, as I said, I don't want to knock the officers. It is quite a difficult time. We're still receiving a large number of applications. We're very good. Hopefully you'll notice that you haven't got these massive applications that are, say, 2011, 12, 13, 14 that you were getting a year ago, and members in this committee were sort of complaining, why are we getting them? So we've sorted ourselves out as part of the planning review. We are processing a large number of our applications within the 8-week periods, and so we're giving a better service to members of the public, and we're not, hopefully you're not getting the complaints as a result of massive delays in applications. That does put pressure. We need to see whether that puts pressure on our appeal stats, and that's part of the review we're looking at to see whether our current working practices have an impact on where we're going. So that's it. Thank you, Chairman.
Just to follow up the point on G&T, obviously members will understand that one of the major factors we've had a problem with is lack of a public site. Councillor Mumford, myself and others have responded to the draft consultation paper on the local plan review to try and insert appropriate wording in there. We are pursuing with both the chairman of the Communities Housing and Environment Committee and with Councillor David Burton, chairman of SPI, and with Martin Cox, to see what we can do about securing a public site. So we are trying to take forward the resolution of this committee in that respect. Mindful of both of this appeal situation and the fact of the matter is that we need to show equality of treatment in terms of affordable housing between the settled and the travelling community, otherwise we could be in trouble, not to mention the fact it's hardly moral. Councillor Wilby?
Yeah, it's just in the report. Councillor Round mentioned this last time. Could it be highlighted what appeals we're losing when we're actually using our own local plan? Because I think there was concern that the inspectors aren't really playing ball with the actual process as well, so that we can highlight, so we've got something to take back to the inspectors to say, you know, we went through the whole process, we spent thousands of pounds on a local plan, and you know, it's been through the inspector and you're still not adhering to it yourselves. So.
That is going to be a substantial part of the work, I think. Any further comments, questions? Sorry, Mr. King.
Before you close the meeting.
Of course, you can always say something, whether it's on appeals or something else.
When you're done with appeals.
We are now.
Chairman, Members of the committee, as you know, I work for a shared service for 3 councils. I've been informed by my manager yesterday morning that due to operational requirements of the shared service, I'm required to cover Swale Planning Committee as of next month, which was a surprise to me, but I thought I'd inform you while we're sitting that apparently I'm required to go to Swale next month.
Oh, well, I hope you return in due course, because, you know, it's the wild frontier out in Swale. No, seriously, they're a lovely lot, but there are a lot of new members in Swale for various reasons, so it's an interesting time for them. Mrs. Snoot, you're looking like you're about to say something. No? In that case, if no one has anything further to say, I will simply thank everyone for their participation and patience on a hot evening, and I close the meeting.
Chair, if I could just update, the ladies are 2-0 up and it's half time.